All right, welcome back to another episode of the Hearse Chaser podcast. Today, it's all about bank accounts. We're talking about savings, checking, even a little bit of CDs. In this podcast, we're going to call this Cash, Control, and Chaos, the bank accounts in estate planning. So stick around. We're going to talk about the common mistakes that we see, how the power of attorney can actually fail you and your family. And we're going to talk about the number one mistake I see with bank accounts. I'm glad you're here. We're going to learn a lot today to make sure that an often overlooked estate planning asset is consistent with your overall plan. Welcome back to the Hearse Chaser podcast show.
You're listening to the Hearse Chaser podcast show. Here's your host, Stephen McClelland.
All right, so here today we're talking about bank accounts, and often when clients come and talk to us about their estate, the bank accounts are often the last thing on their mind. They will talk about real estate, they'll talk about grandma's dishes and guns and IRAs before they ever talk about bank accounts. But the truth is, everybody's got them. And the truth is, people have often multiple bank accounts. And some of those bank accounts today can be set up online and not even hold the money in a brick and mortar store geographically located to the family. So it's more important than ever to understand bank accounts and how they're set up. And now many times the only information people get when they set up a bank account is what is provided by the bank teller. And oftentimes, when people are setting up a bank account, it's kind of a rush thing. I feel like every time I've set one up, I just want it done as quick as possible so I can get in, get out. So if you've set one up recently, it was probably because you moved or you got fed up with your old bank, and so those are kind of the most common reasons that people set them up. So um, it's important to know that the perspective of the bank is that they're not really estate planning attorneys. They're not really thinking about things in terms of the overall estate plan. Oftentimes, they're just trying to set it up so they can get the credit for setting up a new account and then move on to the next person in line. And oftentimes, when you're setting up a new account, you often feel like you're inconveniencing the bank and other people because it kind of slows down their system and of how people come in. That at least that's how I felt. I recently set up a separate business account, and when I did that, so I kind of felt that, and so it's kind of fresh on my mind, which is why I decided to talk about it today. So it's important to understand how the account is set up. Too many times people make assumptions. Oh, my wife's on that account, when the truth is, wife was never put on the account. Or, oh yeah, my son's on the account. Truth is, son's not on the account. So a lot of people make assumptions, and the only way to know for sure is to ask the bank for a signature card. Now, what is a signature card? That's the term of art for, it's typically a one sheet of paper. And I just got my old one here. I'm going to take a look at. The signature card has the name of the account, the owner, that is. It also has, oh goodness, um, who is signing it, and it also has who the beneficiary is. So all the things that you need to know are in that signature card. I can't find it right now, but I know it's somewhere in this paperwork. So unless you have that document, sometimes you don't know. And I think it's really helpful that when you have that signature card, if you put it with your important documents, it can be very clear on how things are set up. So let me tell you probably the biggest point that mistake that people make. So a lot of times when people are hearing their different options for putting someone on the account, for example, I have an account just in my name. My wife has passed. It's just in Steven's name, and the bank says, "Well, you really need to put someone's name on it." Well, what does that even mean? That can mean a number of things. Putting someone's name on it can mean putting a beneficiary so that when I die, the money goes somewhere. But that doesn't help if I need someone to pay my bills. So putting someone's name on the account can also mean giving them signature authority. That's the ability to write checks. That may or may not give you the ability to know how much is in the account. That's actually it kind of depends bank by bank. Let me say what I'm saying is generally every bank has different rules, and probably the best rule to know is the golden rule, which he who holds the gold makes the rules. So it's important to understand how your bank works. And that signature authority is like a power of attorney. So if you know this or not, when you die, you can't use a power of attorney. So I get this call at least once a month. I'd say once a month, 12 a year, 12 to 20 times a year. I get this call. A family member went to the bank and said something like, "Hey, my mom died, and I'm here with the power of attorney to collect the money and then disperse those funds to the kids." The bank will kindly say, "Oh, thank you, Miss So and so, for letting us know. What we're going to do is freeze the account and until we get proper authority." Okay. So at that point, you don't even know what they just said to you, but essentially they're saying you can't use the power of attorney. And the most important document at that time is a death certificate. So if you walk into the bank and say, "Hey, mom or dad died," then they're going to freeze the account. They don't want to give away money if there's a possibility that, somebody has uh, somebody has died. So then they say, "Well, what do I do now?" And if I see a lot of different things here, and let me tell you that sometimes banks will help you out. What you want to know is you might say, "Hey, my name is Sarah, and am I the beneficiary on the account?" And they may look at you like you're warm, you know, but they can't do anything without a death certificate. If they say no, then the money's going somewhere else. And you might want to say something like, "Well, my brother's name is this, and my sister's name is this." And you might get on one of those, and they might say, "I think your brother Tom needs to give us a call." Okay. Um, I've heard of banks releasing money just based on an obituary. And and sometimes that's more common in smaller towns. So if you're in a big city, probably going to be more rigid when it comes to that. It just kind of depends bank by bank. Now, in my state, getting death certificates is quite quick. It takes 5 to 10 business days. We only have 3 million people in our state, so things move and process pretty quickly. Other states, it takes a longer time to get the death certificate. It can take months. In fact, there's a company that marketed to me a number of years ago to potentially help our clients bridge the gap between the time when someone dies and the death certificate. And after talking to them, for 15 minutes or so, I kind of said, "Wait, this doesn't really make sense because we don't have this gap in time." And so they were starting out, and they realized, well, this is the reason we have this business is because a lot of states have a gap, a big gap, 60, 90-day gap between the death and the death certificate. And in that period of time, that bank account's kind of frozen. Here in my state, not that big of a deal. Now, that's not always true, because if there was some some concern about the death, some mystery of the death, or they died on a cruise ship or in another country, that can be delayed significantly. But in most cases, the death certificate is what triggers the bank to release the money. So the power of attorney then doesn't we're talking about putting someone's name on the account. So signature authority and power of attorney don't work. The other one is, well, I can put your child as a joint owner. And a joint owner means that if, like in a husband and wife situation, husband dies, everything goes to wife, vice versa. So there's, as you can see, there's a lot of confusion. What is actually meant by putting someone's name on the account?
Thank you for tuning in to the Hearse Chaser podcast show. Our mission is to be your first choice for last wishes. Want to dive deeper? Join us over at the Hearse Chaser Academy, where we've created 8 on-demand courses for each stage of life. From young adulthood to retirement, navigating separation or blended families, and everything in between, we help you plan for the future, no matter where you're at. Now stay with us as the ride continues on the Hearse Chaser podcast show.
Just generally speaking, I'll tell you some pros and cons things to look at. If you put your kid's name on an account, then they can take out all the money. There is really no restriction there. If I drafted a power of attorney for a child, the child could give the bank that power of attorney and say, I'm the child and I'm the power of attorney. You can't expect that the bank is going to authorize that immediately. What happens is they take the power of attorney, they send it to their legal team, and their legal team looks at it and says, this power of attorney is good, and then it's approved. And I like powers of attorney better here because I've had this problem before. A child's name was on a bank account, and that child had some financial problems. And in the course of the litigation, they garnished all the money out of the account. Now, it wasn't the kids' money, it was mom and dad's money. And, that was a significant amount of money. And as you can imagine, mom and dad were not happy. The solution to that is naming the kid as a power of attorney, and that child doesn't have ownership. They are just an agent. So if that child were to sue, then they couldn't take out the money. Very, very big difference. Not all kids have creditor issues, but that's something to consider. It's also important to know that as a power of attorney, you have to do what's in the best interest of the principal, which is mom and dad. That doesn't look like taking the money out and spending it on yourself. But if you're a joint owner, it's almost like gifted to you. So you have control over it. There's no technical restriction on the co-owner. So it's important to understand that. The term POD is payable on death. So if there was no joint owner, just in mom's name, and the beneficiary was the 3 kids, mom dies, and then the money goes to the 3 kids. So we're going to talk a little bit about what can happen when it comes to those 3 kids. But I first want to talk about just some quick statistics. I found these statistics. I think they ring pretty true. That around 30% of joint bank accounts are not properly titled to avoid probate. I would say that's very, very common. I don't know if it's 30%, but it certainly, I think, has contributed to a rise in probate cases in my state. Our probate cases have increased 20% in the last 10 years, and so I think that's a big part of it. According to the FDIC, there's 88 billion in unclaimed bank accounts sitting dormant in state treasuries. 88 billion. That's just unfathomable. And ultimately, if there is no beneficiary, or if the beneficiary never collects, or if the family doesn't even know the bank account exists, which I think is becoming more common with these online accounts, that money essentially is going to go back to the state where that account was set up, which is great for the state. It'd be interesting to see how much money they acquire every year. As you can imagine, one statistic said as high as 22% of people fight over access to cash assets in a bank account after death. I think that's, for families that have high conflict, that's probably true. And there's probably a lot of confusion. That's probably the biggest concern, is that the family wasn't clear, transparent about things. And uh, the concern, this statistic, over 33% of people over 50, um, only 33%, so only a third, have coordinated their bank accounts with their estate plan. And that concerns me. I think that's probably consistent. I think only half of Americans have an estate plan. And if you try to do it yourself, the do it yourself websites might give you some paperwork, and in there there's probably 15 pages worth of material, and one sentence is, make sure your bank account is set up. And people don't realize the importance of it. And I've had estate plans where, man, everything was set up right except for the bank account. And that is the thing they're frustrated about. They complain, mom and dad had everything set up, the house, the all everything was listed out except for this one bank account. So it's kind of a pain. And and in many cases, the account will get frozen whenever there is a death certificate issued. I had a situation where I had a client call me and say they got a letter from a bank and said, "Hey, we're very sorry about your loss," and they kind of noted that your account is frozen. And the client said, "Well, what should I do?" And I said, "You should definitely go to the bank and bring your ID, because that would be a very funny conversation. They're expecting that you're dead." So it might have been a mix-up on a social security number. The death certificate, I don't know you. The death certificate has your social security number, and of course that gets reported to the Social Security Administration. So that's how they know to stop paying Social Security to that bank account. And if money went in when it shouldn't, they'll take it out. But then that gets trickled on to the banks, and that's how they find out as well. So if that bank account has a beneficiary, okay, that avoids probate. But if it doesn't have a beneficiary, you've got probate. And oftentimes there are so many unintended consequences with bank accounts. So let me tell you a few of the unintended consequences. One, a lot of people, you have 3 kids, they'll just name one kid as a joint owner or name that one kid as the beneficiary. Technically, that kid, it's all their money. They can do whatever they want to. They don't have to share it with anybody. You can imagine some hard feelings that arise in that situation. One of the inconsistencies I see is if you put 3 kids' names on a bank account and one of them dies, in most cases, the POD language at the bank says it goes to the survivor of those 3. And in my experience, that's not really what most of my clients want. They typically want this language. If my son dies, I want his share to go to the grandkids. So that can be very inconsistent. And you might say, well, why does this even matter? It matters because typically the 70 and 80-year-olds, a lot of them have a ton of money in bank accounts or CDs, because they don't want it in the market because it fluctuates so much. So they will have up to 250,000 in a bank, and then they'll open another bank account at another bank, so they can have a significant amount of money because they know, hey, I'm not going to lose it. That's their big concern. So some of these accounts can have a lot. And if you have 200,000 in a CD or a bank account in one beneficiary, technically that's where the money goes. So it might sometimes seem convenient to add a child, but as you do that, you have to start with the end in mind. Think about what actually is going to happen. What goal are you trying to achieve? My preference is to use the power of attorney to give access for the child, because I've seen people get mad at a child and they want to name somebody else on their account. It's much, much easier to change a power of attorney than it is to take a kid's name off the account. So to take the kid's name off the account, you got to get that kid to agree. Sometimes the kid doesn't want to. And really the only remedy at that point is for the parent to take all the money out and start a new account. And you can just imagine how that messes up all the auto drafts. But that is some considerations as well. In my opinion, the best way to be consistent, the best way to handle things is to have a revocable trust. I've had other podcasts where we talk about the benefits of a trust, and the idea of the bank account and the trust is that the bank account goes to the trust when you die. So there is not chaos. It's clear. It goes to the bank account. And what's nice is that whoever's in charge of your trust, they can collect the money and then divide it based on your wishes. I've seen this problem. If you have 3 kids' names on a bank account as beneficiaries, some banks require all 3 to come to the bank to collect their money. Or some require a bunch of paperwork. So administratively, you've got all 3 kids talking to the bank to get out this money, and it might not even be that much to begin with. Whereas whoever you trust to manage your affairs, they can collect the money, put it into the trust, and divide it based on the wishes. So I like that. Is just administratively a lot easier. And clients say, "Oh yeah, that does make sense." You got to make sure that you've got the power of attorney with the POD to the trust. So the trust, the bank account going to the trust at death works, but you also need the power of attorney to handle things while you are alive and incapacitated. And I like there to be consistency. So if your oldest child is the power of attorney, the oldest child is also the trustee. So you want kind of consistency in those areas. Everybody's got bank accounts. It's important to coordinate that. It's important to write things down. These accounts, everyone's got them. And I thought, well, this would be a great podcast for just a refresher on how things are set up. And one of the ways that I think we do a great job of helping our clients is it's not that we don't address how to set up the account, but we give them a letter that they take to the bank. And that helps them immensely because then they don't have to read anything. They just said, my attorney told me to do this. And that has reduced the phone calls and I think led to a better result of getting things taken care of. So if you have a goal for your estate plan this week, check your bank accounts. Think about who gets them. Think about the control of that account while you're alive and at your passing, and make sure it is who you want. And if it isn't, it's probably a good time to make some changes so that you don't have a mess. I hope this episode of the Hearse Chaser has helped. Thanks for riding along with us today, and we look forward to seeing you at the next episode of the Hearse Chaser podcast show.
Hey, thanks for listening to the Hearse Chaser podcast show. Please remember, you can't outrun a hearse, but you can leave your family with a smooth ride.